I might bring in Richard here, and I just wanted to change gear slightly. Listening to the Treasurer's speech this morning and then both of the regulators, we've got this sort of idea coming through that the government would like to see the regulators engage less in sort of quasi-policy making and just enforce the law as it is. The regulators are keen, to provide certainty through guidance that they issue, and to the extent they can clarify the law through litigation and the like. So, Richard, sort of in this type of, with this sort of dynamic unfolding, just wondered if you could talk a little bit around the post sort of Hayne realities for banks and the new risks that perhaps are being introduced into the system when you do have ASIC continuing to sort of pursue the banks, for a range of different offences, larger and larger penalties being introduced, including by AUSTRAC. What do you sort of see as the emerging risks for managing a bank in that regulatory environment?
Yeah. Thanks, James. I think there's been a conflagration of matters over the last 3 years, particularly post-Hayne and particularly in light of ASIC's and other regulators' response to the criticisms of regulators that came out of the Hayne Royal Commission, which all, again, combined to make managing a large financial institution, particularly a listed financial institution, harder now than it ever has been before, and is involving very serious concentration of efforts at senior management and board levels on matters around compliance and matters around risk management, all of which are sensible things for them to have regard to, but the focus now is very heavily in that area, and that's because the prospects of being penalised, the prospects of being investigated, being the subject of enforcement action, then ultimately being the subject of a class action because of the way in which you might have disclosed or not disclosed the regulatory investigation, make this an incredibly difficult space. And I think, in particular, the prospects of penalties now that stretch into the billions of dollars or even into the hundreds of millions of dollars make disclosure questions for major financial institutions much more fraught than they ever have been before. And it means that individuals running those banks now run much greater risks, personal risks, than they ever have before. And I think it is altering the emphasis and the management focus in a way that might not be what we need, particularly in this environment.
I'll bring Karen in on that point. Like, do you see, you were talking about the legal complexity before. I mean, do you see a role and an important role for ASIC and APRA to continue to provide guidance on their interpretation of what legislation means to allow the banks to sort of act with more certainty as to, and avoid these potential risks of a regulator coming back to bite them?
Oh, look, when you have principle-based regimes, you definitely need to know what the regulator thinks good looks like. It can get out of hand, which is what people would say about responsible lending. I think one of the real challenges is that banks are expected to exercise much higher order thinking, fairness, the should we versus the can we test. What are community expectations? And those are incredibly hard problems to solve. And you're really asking banks and to Richard's point, where senior executives are already under a huge amount of stress and scrutiny, and there's a lot of actual fear in the system because of all of this activity. Clarifying what the expectations are is fine, but you're never going to be able to clarify every expectation, every outcome, etc. So we're living in a much more fluid world than we were 5 years ago in terms of what is expected of large institutions.
Anna, I mean, how are the banks feeling about what we're seeing unplay, what's playing out between messages that the government, sending to ASIC as to the level of interference that it wants to see, ASIC conduct on the sector, and saw the Treasurer speaking about this again this morning. I mean, do you sort of see this need for guidance as an important thing for ASIC to continue to do in order to provide certainty?
It's a constant subject of conversation with all of the legislation and the regulatory framework that banks are dealing with, and that is to what extent you want to have a principles-based regime and to what extent you want much more sort of black letter law. And I think at a high level, or most if not all banks would say in the right environment, principles-based legislation gives them the opportunity to have the flexibility to get the right outcomes for individual customers and tailored to their circumstances. But principles-based regulation requires the exercise of judgment, and often subjective judgment, and not always by senior people. Some of the credit assessment officers in regional branches, they're not senior executives on big salaries. They're making a finely tuned judgment about whether they're going to make a loan to that little business to buy a truck, to buy a ute, which could make all the difference to the small business. But if you're close to that line on serviceability, these are the sort of principles-based. You've got to have a tolerance. The system has to have a tolerance for subjective judgment sometimes to be a little further up the risk curve than they might have otherwise been.
And err on the side of making the loan and let the bank take the risk for the losses, yes, rather than assuming some regulatory risk as a result of the decision.
Exactly. But none of this happens in a vacuum. And in an environment where banks have experienced a considerable loss of public trust and loss of reputation, where there's been a Royal Commission, where there's been the Royal Commission didn't only examine banks, but they examined regulators, and were quite critical of how regulators enforced or didn't enforce, etc. So all of that together combines to an environment where there's actually not a lot of tolerance in the short term for people to make subjective judgments based on some high order principles.
Yep.
And everybody looks for, again, the credit officer in the regional branch, they say, just give me exactly what I have to do. I don't want to take the personal risk, yeah, of making a judgment that might, in 4 years' time, be judged to have been the wrong call. And, the pandemic makes that even more complicated. The level of uncertainty in which banks are making judgments right now, when, I was listening to your previous speaker, Mark Hand, and he's right, in the absence of a vaccine, without knowing when international borders are going to open, banks are going to have to make judgments, and the community will expect them to make the right ones to help everybody. But they're going to be hard calls, and they're going to require a level of comfort and tolerance for risk based on reasonable assumptions.